Todos, bienvenidos nuevamente. Muchísimas gracias por estar aquí en un evento más que estamos haciendo el Colegio de Corredores Públicos de la Plaza del Estado de Jalisco y el TEC de Monterrey. De verdad es un gusto. Gracias, Pedro, por estar aquí, por acompañarnos. Gracias por este evento en conjunto. Gracias a todos los presentes. Y gracias también a nuestra expositora, Sara, quien nos va a hablar sobre las ventajas de resolver todas las controversias tecnológicas a través de arbitraje. Thank you, everybody, for being here. Thank you, Sara, again, for being with us. Welcome again. Gracias y le cedo la palabra a Pedro. Gracias.
Hola, Karen. Muchas gracias y gracias a todos. Bienvenidos. Le agradecemos mucho al Colegio de Corredores Públicos del Estado de Jalisco que nos apoye en difundir estos temas que para la carrera de Derecho en el TEC de Monterrey son sumamente importantes. Nosotros creemos que la transformación digital tiene que ser tomada en cuenta por los abogados y este tema ayuda y abona para que los abogados puedan tener los conocimientos y las competencias necesarias para subirnos a la transformación digital y que no nos arrolle la transformación digital. Entonces, es un tema sumamente importante para los abogados y muchísimas gracias por la invitación y a la expositora que sé que será muy útil para todos los participantes. Muchas gracias.
A nuestro moderador, el licenciado Agustín Vargas. Adelante, toda tuya la sesión, Agustín. Muchísimas gracias.
Muchas gracias. Gracias a ustedes, Pedro. Muchísimas gracias por considerar al colegio. Karen, desde luego, por tu iniciativa. Sarah, thank you very much for being with us. We are really honored to have you with us, and we are really eager to get some of the things you have to share with us. So then again, thank you very much. So in order not to take too much time from Sarah, who is the one we really want to hear, so I'm just going to straight away to mention some of the highlights of his professional background. Sarah Reynolds is managing partner of Goldman Ismail, a US-based dispute firms, and the CEO of Silicon Valley Arbitration and Mediation Center. In her practice, Sarah represents technology and pharmaceutical companies before domestic and international arbitral bodies. Thus, disputes range from complex commercial supply agreements to IP licensing and technology development agreements. Sarah's arbitration experience also includes obtaining and defending against judicial review of arbitration awards and drafting and reviewing arbitration clauses in enterprise critical transaction agreements. Sarah is a fellow of the Chartered Institute of Arbitrators and is a Center for Conflict Resolution trained mediator. Sarah is also named of the ICDR panel of arbitrators and mediators and the Hong Kong Center for International Arbitration list of arbitrators. So I think the subject that she's going to share with us is of main importance now towards the future. And I think for all the experience that she had, we are going to get a lot of good knowledge out of this session. So thank you everyone to be here. And Sarah, we are really eager to hear from you. So now you have all our attention.
Thank you. Muchas gracias, Agustin y Miriam, Karen, Pedro, muchas gracias. Y buenos días a todos. I'm very happy to be here today. I was honored to be asked by Miriam to speak with all of you. I'm always happy to talk with people who are enthusiastic about arbitration and other forms of ADR. I don't know about Mexico, but in the United States, our courts are experiencing serious backlogs as a result of COVID-19 closures. And so getting cases through courts right now are very difficult. And so we see a lot of people turning to ADR and arbitration to move their disputes forward, which is a good development for people like me and people like us that are interested in this practice. But again, it's a privilege to be here with all of you. So as was mentioned, I'm the managing partner of Goldman Ismail. We're a disputes only firm, a boutique firm located in Chicago, though we litigate cases nationally, mostly for pharmaceutical and technology companies. And then separate and aside from that, I'm the CEO of Silicon Valley. And I just want to spend a minute talking about Silicon Valley, because the name is sort of a misnomer. The organization is based in Silicon Valley, but it really serves a global technology sector by promoting business practical resolutions of disputes. And we focus on efficient technology dispute resolution, including advancing the use of arbitration and mediation in technology and technology-related business disputes around the world. So just because we have Silicon Valley in the name doesn't mean that people like all of you would be welcome to join. We provide educational programming and related resources to technology companies and to arbitration practitioners, law firms, in-house counsel, and the like. We do not administer cases, so we are not like the ICC or the ICDR. We don't actually administer cases. What we do at Silicon Valley is we collaborate with leading ADR providers, technology companies, law firms, neutrals, universities, like yours, to address the merits of arbitration and mediation as a way for resolving technology and technology-related disputes. We publish an annual list of the world's leading technology neutrals. So these are arbitrators that are highly acclaimed, they're peer vetted, they have exceptional qualifications and experience acting as a neutral in technology-related disputes. We call it the tech list, and you can scroll through the names on our website. We are currently looking to internationalize the list and to add some, more practitioners who are outside of the United States that can help resolve some of these disputes. So I just encourage all of you to take a look at our website. It's svamc.org, and consider getting involved. There is a young practitioners board that is free to join if you are under 40. That may be of interest to some of you, but we'd love to get anyone who is interested involved. So for today, I plan to use our time to talk about two things. The first is why alternative dispute resolution makes sense for technology agreements in particular. And then secondly, to spend some time talking about and thinking about why disputes happen with respect to technology agreements and how you can minimize that risk with a focus on arbitration clauses. So lots of our clients, as litigators, we get the disputes have sort of already happened. The agreements have already been written. The clauses have already been written. But there are some things I think we can do to educate our transactional colleagues to help avoid disputes happening down the line. So let me start off with a description of the common areas of disputes in technology agreements that we see. And there's some common characteristics to those disputes. It's a wide range, right? So the types of technology agreements that we see day to day that result in post-agreement disputes range from software or pharma licensing agreements, software or pharma development agreements. We see a lot of long-term IT or other technical service agreements, joint ventures, and other collaborations to develop new technology. And then separately, in addition, we see a lot of disputes resulting from technology implementation agreements. And so this is where somebody buys a software or some sort of technological solution, and then, from some company who is supposed to implement it, and then the expectations aren't met and a dispute arises. So even though there's a range of the type of agreement from which these disputes are arising, they do have some things in common. And I think it's useful to focus on the commonality, because it's informative in thinking about why these disputes happen and what we can do as lawyers to prevent them from happening or minimize the risk of them happening for our clients. So these disputes tend to be high value. And that reflects the high value of the underlying contract or the potential impact on the company's business. So it's usually high dollar amounts at issue. The technology often involves trade secrets or other forms of proprietary information, intellectual property, patents, trademarks, copyrights, a lot of source code, things that companies are looking to protect and want to prevent public disclosure of. A lot of these technologies live and die by their source code. That is, their real source of value. And so the risk of that being disclosed or disseminated publicly through a domestic court proceeding is very high. Or the harm, I should say, the harm that would result if that were to happen is high. So even if the risk is low, parties are generally not interested in taking the risk at all, given the potential consequences. These disputes also tend to be very fact-intensive and highly technical in nature. And so as a result, establishing where fault lies can sometimes be difficult. And this is particularly true because since both parties in a technology disputes are sometimes at least partially at fault, these are situations where there tends to be fault on either side, where nobody executed perfectly. And so both sides can point to the other as having failed to meet expectations, which adds a layer of complexity to the dispute and again increases the intensity of the factual investigation that you'll need, and usually moves you into an area where it's not as, the law doesn't clearly pick a winner and a loser. The fault lies somewhere in the middle, which we can talk more about later, but arbitration is particularly good and well suited to resolving disputes like that. Unlike domestic judges who sort of need to pick a winner and a loser, arbitrators can usually come up with a more refined, bespoke resolution that more adequately meets the actual distribution of fault between the parties. So the good news is that parties to technology agreements often have strong incentives to resolve disputes early, to preserve commercial relationships, and to keep progress moving forward. These are usually parties that are trying to build something together. We see this particularly with agreements to collaborate on technology, to develop new technology. And that's a really great place for your parties to be. Even though they're having a dispute or disagreeing about something, they're not necessarily looking to entirely break up. What they're looking for is, we see this, another area where we very frequently see these kinds of relationships are in the construction arena, where the parties are too far into a deal, the project is too big, they're not getting along or disagreeing about something, but they're not looking to part ways. They're looking for somebody to pick a winner and a loser for this dispute so that everybody can get back to work and move the project forward without significant delay. And so arbitrations, the speed at which arbitrations are decided is a real advantage to parties in that sort of collaborative situation who are looking to get back to work together. And there are a lot of procedural options for parties in arbitration. Arbitration offers a greater range of procedural flexibility. And so clauses can be written to accommodate that. And we even see clauses where, disputes under a certain dollar amount will be decided by a sole arbitrator under expedited circumstances so that minor disputes don't blow up entire deals. And instead the parties can get through those and get back to work. And then, above some dollar amount threshold that's much higher, then the parties will start looking at, 3 arbitrator panels to decide the dispute and more extensive procedural rules. So let's talk about why and I've mentioned a few of the reasons why, but let's talk about why alternative dispute resolution makes sense in technology agreements. And many of these things I suspect you all can guess, right? Because they're not that different for why arbitration makes sense in almost any sort of dispute context. But there are a few things that are of particular interest to technology clients. And so the use of arbitration and other forms of ADR to resolve domestic and cross-border patent disputes and other IP and technology disputes can really present a more optimal approach to dispute resolution than traditional litigation for a wide range of potential business disputes. The generally applicable advantage of arbitration over litigation include typically shorter resolution times. And so this is something that, I mentioned before. If the parties are looking to build something together, they're having a disagreement, they want that disagreement resolved quickly, a lot of times they don't even necessarily care. They're less focused on whether or not they win or lose that particular dispute and more focused on getting back to moving the project forward. You also avoid, and this is true in any dispute, it's not particular to technology disputes, but arbitration allows you to avoid potentially biased foreign domestic courts. A lot of technology agreements are cross-border. That's particularly true with respect to pharmaceutical development agreements and licensing agreements, as well as other technology agreements. If you're in a cross-border circumstance, clients are very hesitant to subject themselves to the domestic court of a foreign state. There's, not all states are created equally, and there are some states where your chances are as good in that particular state as they are in your own home state. But there are some places where you would be concerned about a pretty significant home court advantage for the party that is actually located in that state. And so a lot of clients are hesitant to engage or to subject their disputes to foreign domestic courts. And arbitration allows you to sort of get out from under that. So the appeal of arbitration and other forms of ADR is really amplified with respect to patent and IP disputes and also disputes using source code. And that's especially true when the underlying technology is complex. The additional advantage of arbitration in this context is the ability to choose your decision makers. So unlike being subjected to a generalist judge in a domestic court, what arbitration allows you to do is to select decision makers that have relevant technological or industry backgrounds. And that can be really important if you have a complex technology. If you're dealing with software, pharmaceuticals, medical devices, things that are relatively complex, parties usually want a decision maker who has relevant background, who understands the industry and industry customs, understands the unwritten rules within the industry and has operated within them, and also who understands the underlying technology and won't require a lot of education on that. Having to educate generalist decision makers about, highly technical concepts, while not impossible, certainly does take a lot of time, and, time is money for our clients. And that's assuming that you're going to be in front of a judge. That problem becomes exacerbated in instances where, like in the United States, you are frequently in front of a jury for a lot of these things. So then you're having to educate, 12 or whatever the number is, citizens, from all different backgrounds about highly technical concepts. And that is usually not a place that most clients want to be. So that is really, in my view, that is one of the best advantages of arbitration, is that you can put qualifications, you can write them right into the clause, that the person has to have so many years of experience within a particular industry, that they have to have, certain licenses, or whatever educational backgrounds or other credentials you want to see in the decision maker. And then, of course, if you have a 3-arbitrator panel where each party is picking a wing who will then pick a chair, you can select a wing, whether or not it's in the clause, that has whatever credentials you and your client view as appropriate. So that is really a sort of, when I'm talking to clients about options, the fact that you can get a decision maker with relevant technological or industry background is usually very persuasive to them that arbitration is likely the way to go. The other point to make, and the other real advantage that arbitration presents in the technology space, is procedural flexibility. So, and I alluded to this earlier, sometimes in these disputes, you have smaller disputes that you're looking to just resolve quickly so everyone can get back to work. And arbitration allows you to have procedural flexibility, and so to have sort of a lighter dispute process in order to favor speed and efficiency for lower value or less important disputes, and then to have sort of more procedure and more thoughtfulness for larger, more expensive disputes, which is a great flexibility, that is a flexibility that's a real advantage within the technology space. But I think specifically what is helpful with arbitration is the procedural flexibility that parties can adopt with respect to experts. So we don't have to follow, in arbitration, it's actually fairly rare to follow a traditional format of presenting expert evidence in a dispute. And so rather than having the expert get up and do a long direct examination, and then the other side conduct a cross-examination, and then the counter expert goes, you can actually do all sorts of different things with experts in arbitrations. Frequently, the arbitration panel will select an expert itself. It will select its own expert who is a neutral expert that is there to explain issues and concepts, but not acting as an advocate for either side. They have a procedure called, which is, it's not a great name, but it's called hot tubbing, where the experts that are an expert and the sort of counter expert to that, so opposing experts on the same topic, will actually testify together. And so they will get up in front of the arbitral panel. Sometimes the arbitral panel will allow them to give a short presentation on their report, and then the panel asks the experts questions as opposed to the party advocates guiding that discourse. And even when you're in situations where you are guiding experts yourself and presenting their evidence, you don't necessarily, direct examination for experts, particularly highly technical experts, is not always the most effective way to deliver the information. It's complex information. You need the decision makers to understand it. So you want to come up with a way that's highly impactful in delivering that messaging. And so frequently what we'll see in arbitration is that rather than a question and answer direct examination, the experts will be afforded, an hour or some predetermined amount of time to just get up and give a presentation. And then that is their direct testimony in addition to the written report that they filed. And then the opposing side can cross-examine them, or the tribunal arbitrators can ask questions themselves. That flexibility allows parties to present complex expert testimony and evidence in a much more efficient and effective way. And you don't see that kind of procedural flexibility if you're in domestic courts. So particularly when you're dealing with, highly technical disputes, that is a real advantage that arbitration has. And then the other real selling point for arbitration when it comes to technology agreements and disputes is that there's greater protection for confidential information. So like I mentioned before, these companies really live and die by protecting their proprietary information. It would be disastrous for the company in many cases. A lot of their value is derived from that information if that were to get out. And in domestic courts, there are just protective orders and all sorts of, redactions and filing things under seal. But none of it is magic and none of it is bulletproof. And we've seen again and again, leaks and mistakes where information has gotten out that shouldn't have, in ways that were very devastating to companies. Where arbitration, the one caution I will say is that most arbitral institutions, if you look at their rules, confidentiality is guaranteed to the extent that the arbitrator or the institution is prevented from talking publicly about the matter. But it is usually not necessarily the baseline rule that parties are subject to confidentiality restrictions. That said, almost every arbitration clause you will see has a confidentiality provision written into it to prevent the parties from speaking publicly about the arbitration or releasing any information. And so that greater level of protection is really meaningful for a lot of technology clients. And so usually if I don't convince them with, talking in cross-border disputes about the ability to avoid foreign domestic courts, or the ability to choose decision makers, usually by the time you get to a conversation about, what kind of information is involved in this dispute and what are the consequences if that were to be, accessible to the public, usually by the confidentiality point, most clients that are entering into technology agreements are convinced that ADR is a better option for them. So arbitration there are a couple of things. We can't talk about all the good stuff without mentioning the bad, right? And I'll put bad in quotes because I think for all of these things, there's a way to argue that it's actually good. But I think it's worth taking a second to talk about what you're giving up with respect to arbitration. You are giving up appellate rights in most cases. So at least, and I'd love to hear, how it works in Mexico, but in the United States, if you lose at a trial court, you still have various levels of appeals ahead of you, which is great for ensuring the result is legally correct. The disadvantage is that it takes a very long time. And so arbitration, in most cases, there are some institutions where you can agree to a sort of quasi-appellate procedure prior, at the stage where you're entering into your agreement and drafting your clause, or later on if you can get both parties to agree to it. Though in my experience, if it's not in the clause, they're never going to agree to it. There are some sort of quasi-appellate procedures that you can take advantage of, though I think most people who are engaging in ADR are looking for a faster decision and are willing to give up their appellate rights because they are more interested in speed and efficiency. And then some institutions like the ICC, for example, has a award review process. They call it a scrutiny process, where after the arbitrators draft an award, the award goes to a panel of other qualified people to review, just to make sure there aren't any obvious errors or mistakes in it, to ensure a high quality award. But beyond that, you're really giving up your appellate rights if you're in the ADR space. And then the other thing you're giving up is the leverage of publicity in most cases. Like I said, most cases have a confidentiality agreement, which means you're not going to the press, you're not going to the New York Times or whatever the equivalent is in Guadalajara to talk about the dispute. You're not you can't threaten going public with the dispute if the other party doesn't comply or settle, because you're likely prevented from doing that in this context. So those are that's what you're giving up, but there are ways to see both of those things as advantages as well. So another reason that arbitration is favored as a means of resolving IP and other technology disputes is because of the New York Convention. I'm sure you're all familiar with the convention, so I won't spend a lot of time on it, but under that convention, awards issued by arbitral tribunals are enforceable in most jurisdictions worldwide. So it calls for the enforcement of arbitral awards in any signatory state issued in any other signatory state. And that is a really important advantage. So if you win a case, or if you get a favorable order in a domestic court, you can generally enforce that order with other domestic courts in that same state. But if you're in a cross-border context where you need to enforce an award outside of that particular state, which is very frequently the case, you're out of luck. And so what an arbitral award from a signatory country allows you to do is to go and enforce that award in any other signatory state around the world. And it's a broad level of adoption. The US, Mexico, China, most UN member states are all members of the UN Convention. So that means that if you have an award that affords you, where you win a certain amount of money, you can go enforce that award against assets that the other party has in any one of those countries. So it really broadens your access from an enforcement point. And if you have some kind of an injunction, an award that says they have to start doing something or stop doing something, you similarly can enforce that more broadly than outside of the domestic court where the award was issued. So Article 2.1 of the Convention provides for the recognition of an international arbitration agreement concerning a subject matter capable of settlement by arbitration. So this raises the threshold question of arbitrability. Once you have an award, there are very narrow grounds upon which somebody can invalidate that award, but one of the grounds is that it has to be an issue that is arbitrable according to the laws of the seat. So that is the place where the arbitration happened in most cases. So a party can seek to vacate an award where the National Court of Enforcement determines that the subject matter of the dispute is not capable of settlement by arbitration under the laws of that country. There are some caveats related to patents where there are limitations to what you can do with an arbitration award related to a patent dispute in particular. So most commercial patent disputes involve rights or obligations derived from contracts. So these are assignments, license agreements, and federal statutory law in the United States provides that these ownership disputes are arbitrable, which is good news for arbitration. But some disputes, on the other hand, involve rights that are derived from government entities. So these are things like infringement or validity, as opposed to these ownership type claims. So in the United States, these patentability disputes are arbitrable, but the awards are only enforceable. They're not enforceable against non-parties. So if you and I enter into an agreement that has an arbitration clause and we have a fight over the validity of a patent or infringement of a patent that is subjected to arbitration, when we get that award, we can enforce that award between each other, but we can't enforce it against a third party. If you want to do that, you have to go to the federal circuit court and deal with it through domestic courts. So patent rights are an issue of public policy. They require state action to be invalid. And so an arbitral award invalidating a patent in the United States will not preclude the patent owner from asserting that same patent against non-parties. Now, this isn't true everywhere, and that's sort of how the United States handles this. There are, I think it's Belgium in particular, and Switzerland treat this very differently, where if you have an award regarding infringement or validity, it is enforceable against non-parties, but the United States takes a narrower view of that. But as a general rule, parties can take comfort that U.S. courts will uphold agreements to arbitrate and enforce arbitral awards. They will only invalidate them on very narrow grounds, and that is true in the context of almost all technology disputes, with some narrow caveats for infringement or validity patent decisions, and it is true in most New York Convention signatory countries. So a lot of global support for arbitrating these kinds of disputes. So with that said, I'd like to move on to talking about what we can do, sort of why patent or why technology disputes arise, and what we can do to help minimize the risk. We're never going to eliminate them, right? Parties are always going to fight about stuff. No matter what we do, they will find a way to fight about stuff. But I think there are some things that we can do to help limit the occurrence of these disputes, which, clients are always better off with avoiding, if they can avoid a dispute process. Because even if anytime you have to litigate to get to an outcome, you will find, I'm sure many of you have found in your practices, that when a client has to litigate to get what was right in the first place, they're usually disappointed even when they win, because they wasted a lot of time, they wasted a lot of money, it was a lot of stress and work. So to the extent that we can avoid disputes for clients, the better off they are. So let's take a look at some of the typical reasons why disputes in this context arise. One thing that we see is a lack of clarity in the contract as to the roles of the respective parties. So who is supposed to bear what risk? To the extent that that isn't clear up front, a lot of times people, even though they're not, clearly stated expectations in the contract, if people are holding those expectations and there's a lack of clarity, a lot of times we end up with fights down the road. Another source is that one party believes the other party has failed to perform its contractual obligations. And then we see instances where, and that's a pretty typical breach of contract scenario. And then we see instances where commercial interests of the parties diverge or they change. So what they wanted on day one when they entered into the agreement is different than what they want, 6 months in or a year in or years in. We also see a lot of disputes that result from a lack of transparency. And so this is where you're sharing information, or you're supposed to be accounted to for royalties, but you can't really tell what the other side is doing. There's not a lot of clarity. So you become concerned that there's misappropriation. So you're concerned that there's unauthorized use of a party software, trade secret, or other proprietary information, some kind of misappropriation. You are concerned about representations about who owns the technology that's being developed. And then we see it frequently with respect to royalty disputes. So this is where you can use my technology, but you have to pay me, every time you make a sale, or, whatever whatever is decided in the contract, but I don't have any visibility into how many sales you're making. And so you're paying royalties, but I have no way of knowing if those royalties are accurate, or if you're cheating, or, or what's going on. So we see a lot of disputes resulting from a lack, that I'll just sort of put in a catch-all category of a lack of transparency. And then we also see situations where the deal structure is one-sided. And so, you have a lawyer who aggressively wins a point in the deal. But that winning that point, if it's an overreach, doesn't always do you any good if the whole agreement is going to fall apart post-agreement because the deal was fundamentally unfair. So while it's sort of great in the short term to win the point, you really have to think about whether or not it's affecting the sustainability of the whole project. And if it is, think about whether or not it's worth winning in that situation. Sometimes this desire to win the deal, if it pushes too hard on the price or makes the deal too marginal, that increases the likelihood that a party is going to, have diverging interests, change their mind, or decide that it's more efficient to just breach the agreement rather than to continue to collaborate. And then with respect to implementation agreements, we see this a lot, where there are unrealistic implementation timetables that are driven by commercial pressure. If you start off with unrealistic timelines, and there's going to be disappointment and breach starting from day one. And then we also see situations where there's unrealistic internal expectations as to what the likely savings or the profits from the deal are. It's very important to be very realistic about how, about what the implications of the deal are. Is this a good, what are you going to make off of this realistically? To sort of move away from the sales pitch and think practically about, how much are you actually going to save by implementing this technology? Or how much are you actually going to profit by, entering into this deal, and having a realistic expectation with respect to those finances. So this brings me to sort of the last section here, and that is, what can parties do when you're negotiating these technology agreements? What can you do to minimize this risk down the line that there are going to be disputes related to these things? I think that honestly, just putting some thought into why disputes happen and sort of running through this checklist of categories of sort of reasons for disputes is very helpful. It sort of puts these things in your head so that you are able to, think proactively as you're negotiating the agreements to avoid some of them. And so I think being realistic about the resources needed to manage a technology contract is very important. You can't sign the agreement and put it away. You have to dedicate resources to ongoing monitoring and compliance. You also have to limit agreements to agree later. When people are entering into deals, that's also, that's sort of that's the wedding, right? People are happy, people are excited to work together. and they don't necessarily want to think about what happens when we don't get along anymore. It feels like bad luck at the time. But I do think that sort of the secret to a strong commercial relationship is having really clear expectations. And that is particularly true with respect to dispute clauses. If you have a really strong dispute clause where it's really clear what's going to happen if a dispute arises, it allows parties, frankly, to proceed into the deal with more confidence. And that's what we want to see. And you really want to avoid agreements to agree, particularly with respect to arbitration clauses. We see a lot of clauses that don't say, for example, whether it's going to be one arbitrator or three. It says, we'll determine that later when we know what the dispute is. It is going to be far easier to agree to one or three, hypothetically, at the point that you are entering into the agreement. Once the dispute arises, it is difficult to get parties to agree to anything, whether it makes sense or not. And you're going to end up litigating. You're going to end up wasting time litigating, whether it's one or three. You honestly, in most instances, the clients would be better off. Even if they wanted one and the other side wanted three, they're almost always better off having three in the agreement and going ahead with three arbitrators than litigating that threshold question of how many decision makers are going to be involved. So I really encourage you to look at those clauses and make sure that there aren't a bunch of agreements to agree. That optimism that exists at the beginning of a deal dissipates pretty quickly as things move along and as the parties get into actual disputes. So again, you really want to make sure you're including effective dispute resolution clauses. Consider you can write in accelerated processes for smaller or technical issues, for more minor disputes. Not every dispute needs to blow up the deal or the relationship. I'm clearly biased on this point, but an arbitration dispute clause is a great way to support longer term commercial relationships. And so thinking through a practical dispute clause will save your client a lot of heartache down the line. And then you also want to make sure that there are realistic project milestones and clear consequences for failure to perform. When you have partial performance on both sides before a dispute arises, the legal inquiry gets very mucky. That's what we talked about earlier today, that earlier in the presentation, that the fault often lies on both sides here. And so if you have clear milestones and clear consequences for breaching those milestones, that it sets expectations up front, and the parties sort of know where to go from there. And then as a preliminary matter, when negotiating dispute clauses, clients should be insisting on arbitration versus litigation, in my view, in just about any cross-border deal. If the deal is cross-border, there are very few instances where your client's going to be favored by being in a domestic court. It's unlikely, frankly, that the other side, if they're a party from out of state, that they're going to be willing to be subjected to your particular court. So I think if you're in a cross-border situation, almost always you're going to want to have an arbitration clause written in the provision. The next question I ask clients is, okay, even if both the parties are from the same state or that the other party is willing to agree to the arbitration being seated in their home state, then the next question is, how important are appellate rights? And if the answer is not very important, then I would still suggest the clients really consider technology agreements. We've gone through the advantages of disadvantages of that, particularly with respect to technology agreements. But that I think there's given that the advantages are so overwhelming in the technology context that you almost can't go wrong with an arbitration provision. And so I think as a final thought, I don't know if there are any transactional lawyers on the call. Us litigators understand that the dispute clause is not the most important negotiation point in the moment when a deal is being is being negotiated. And so it's really easy for us litigators to sort of point back at the transactional lawyers and say, like, well, if you had done, this, that, and the other thing, this dispute never would have happened, or would have, or our client would have been in a much stronger position. We understand that there are more important points to negotiate. But what I always try to impress upon my transactional colleagues and, to students who are learning about the law is that when someone calls me with a dispute, the first clause that I look at, and I don't think I'm unique in this way, I suspect that most litigators do the exact thing. I don't look at the parties. I don't look at the amount in controversy. I don't look at the damages clause. The first thing I do is I flip to find the dispute clauses. That's the starting point. That's where you start thinking through your options. That's where I start thinking through what the potential strategies are. And so it's worth some thoughtfulness on the front end to develop strong dispute clauses. And like I said, a strong and clear dispute clause allows parties to proceed more confidently into a commercial relationship. And I'd love to hear about all your experiences and practice and where disputes related to technology agreements have arisen, and thoughts about how they could have been prevented or minimized by better front-end drafting. It's an area where, unfortunately, many of the lessons are learned by first confronting what at least appears pro hoc to be a mistake. So these are lessons that are in many ways learned the hard way. And so I think the more that we sort of think through, at the end of every dispute that I litigate, I sort of try and go back to the beginning and, and think about what could this client have done differently or better in order to prevent the dispute? What could this client have done differently and better to have gotten themselves into a better dispute process that would have more efficiently resolved their issues? And I just encourage all of you to give some thought to those things as well.
Well, I think it's been really enlightening, and this overview, Sarah, make the points really clear, I think. Thank you very much for that. We have a couple of questions. So two are related to place. So do you think there is a preference place for technology disputes on arbitration? And the second one related to place is, do you think Mexico is a good place for to be considered for arbitration in technology disputes? And the other one goes to, if you know there is any institution specialized in technology disputes. I'm not sure if WIPO should be considered as institution, or that's the intended questions. So what are your thoughts about that?
Sure. I think Mexico is a great place to arbitrate disputes. I think you have rosters of really talented arbitrators among you, which is one of the first things you need to consider for place is, the first things to consider is the domestic courts. Are the domestic courts going to enforce arbitration awards? Are they going to enforce arbitration agreements? And I think Mexico has proven to be an ally on both of those fronts. And then the second thing is, do they have arbitrators that are, skilled and experienced in these types of disputes? And I think the answer is yes, there too. It's also a nice place to be. If a bunch of parties are going to have to be somewhere, you might as well have it be a nice place. So I think Mexico is a perfectly fine seat. I see it come up here and there as a good neutral spot. A lot of agreements that involve U.S. and Canadian parties will pick Mexico as the seat. If there were a dispute to arise, it's sort of spatially, geographically convenient to both of them. And they're relatively comfortable with the circumstances in the domestic courts. And it's, the Canadians like to escape the cold and head down to warmer temperatures. So I do think Mexico has a lot of promise as a potential seat. And then in terms of preferred places for technology, what I'm really looking for is whether or not the domestic courts are, it has to be a signatory, right? So it's easier to sort of point out the bad places, right? Anywhere that is not a signatory to the UN or the New York Convention, you don't want to be. Anywhere that does not have, where their domestic courts have not been supportive of enforcing arbitration agreements or enforcing arbitration awards, that's not where you want to be. And just about anywhere else is okay. There are a few sort of things you have to look at. For example, some of the Middle Eastern countries don't allow, they have Sharia law in place and don't allow things like interest or punitive damages. And if those are things you're after, you need to think about whether or not that's the right place to be. You just have to look at the domestic courts and how sort of proactive they are about arbitration. And then you want to pick a place where your client wants to be, right? And, if your client's going to have to go hang out there for a few weeks, somewhere that's, going to have good facilities and access to good arbitrators and things like that. So I would say it's easier to pick out the places that are sort of have like a red X over them. Like you're not going to North Korea or, some of the other places that are not signatories. And then I think the other question was about institutions that focus specifically on these types of agreements. And there, I think the answer is WIPO is certainly one of the leading institutions, particularly for IP disputes. But we see lots of institutions dealing with, highly technical disputes, whether or not they have that specialty. The ICC is sort of the gold standard in Paris in terms of handling just about any commercial dispute. I think the ICDR in the United States has a pretty respectable track record. We see a lot of these disputes going to Singapore. It used to be Hong Kong, but with different political scenarios playing out in Hong Kong, people have some concerns about Hong Kong's future and the future of courts in Hong Kong, and whether or not they're essentially going to be swept into mainland China. So now you see clients selecting Singapore over Hong Kong more and more. But there are, and then there's a lot of, the other thing to think about too is cost. Paris is very expensive. And so there are a lot of clients don't necessarily want to go through the expense of spending a month in Paris for one of these arbitrations. And I think that is an area where a place like Mexico really wins. 4 weeks in Mexico is far less expensive than 4 weeks in Paris or London. And that is a point that is very appealing to a lot of clients.
Thank you very much. We have another question. What does Sarah think about mediation, better known as switching hats? And then, if the settlement reached should be enforceable, what do you think about that?
Sorry, could you repeat the question one more time?
Oh yeah, there is a thing called switching hats, which should be arbitration mediation. So what do you think about that in technology disputes? And if any given award should be enforceable?
If the parties agree to it, it should be enforceable. In my own practice, you do have, sort of these med-arb clauses and processes, which I'm not opposed to, and I think they're fairly effective, oftentimes in resolving the dispute entirely early, and other times in just narrowing the dispute, which increases speed and efficiency on the back end. The parties have to agree to it, and in my view, I generally want the mediator to be somebody different than the arbitrator. It's usually hard pressed to get me to agree that the same person should mediate and arbitrate. For both, they're very different processes, and for them to be effective, you need to be able to communicate more freely with the mediator than you would necessarily want your client to with an arbitrator.
Okay. Well, meanwhile, we have any other question, I will ask to have your opinion, because let's say in any given controversy, when there is, let's say, a trademark or patent, and then the parties go into a claim and counterclaim, saying that the trademark or the patent should be null and void. I don't think, and at least in Mexico, in my experience, that the award should declare that the patent or trademark is null and void, because that should be going to impose into the institution, which is the authority, the obligation to do or not do something, and goes beyond the parties, and in the opinion of some, should be beyond the arbitrability of the dispute. So in your experience, how that is working? Any arbitral tribunal is awarding maybe that the trademark or the patent is null, void, and the institution is actually executing that award, or what is happening in that regard?
So what's happening with respect to institutions enforcing awards or enforcing awards from institutions?
Yeah, when the institution is not just following the lead of the award, let's say there is an infringement, okay, but indicates that the trademark or patent is null, they should nullify the said trademark or patent.
Yeah, so that is a complex question that will and the answer will very much depend on what country you're working in, because the answer will be different depending on what country you're working in. So I do think for these technology agreements, you need to spend some time thinking about how a domestic court treats these disputes. For example, I talked about the limitations in the United States too. So if you got an award that invalidated some kind of IP in the United States, that would only be enforceable as between the two parties. You couldn't go, if you won that, you couldn't enforce that. Like let's say you accuse somebody of infringing on your patent, and you won an award in the United States saying that was true, that they were infringing. You can't take that award and go enforce it against another person you think is infringing. Where if you were in Belgium or Switzerland, you could do exactly that. So it very much depends on where you're at. And if the arbitrator, and the reason you need to know is because you want to make sure the arbitrators understand the limitations to their jurisdiction, because if they write an award that overreaches and goes beyond what that, what the state allows, then that is grounds for, they've made a decision on something that isn't arbitrable, and that is grounds for invalidating the award. So that requires some careful analysis on the front end.
Okay, thank you. We have one more question. I'm not sure if this is what he wanted to know, but considering that you waive your right to appeal in a domestic court, what can you do due to the complexity of the dispute if the arbitrators make a mistake in their decision? So
yeah. That also depends on what institutional rules you're using. So most of the rules, like the ICC, for example, have a process built in where if the arbitrator's made, for example, a math error in calculating damages, where you can go and get that corrected, they will not change the substance of the award, right? It won't change who won or who lost. But if there's some sort of obvious error, like a typographical error or a math error, that is very visibly a mistake and not what the arbitrators intended, where they will go back and fix that. That part of the reason that I like the ICC is that because they have that award scrutiny process, a lot of those errors get taken care of and fixed before you even see the award. But beyond that, that is something that you are giving up in most arbitration proceedings, is your opportunity to appeal. You can seek to invalidate an award, but under the New York Convention, there are a limited number of enumerated grounds for doing that most courts, the US included, have further construed very narrowly. And these are really egregious situations, like the arbitrator accepted a bribe. Very egregious, and like a manifest disregard for the law or getting the law wrong is actually not one of the reasons. So the arbitrator can get the law wrong and the award will still be enforced in most states.
Thank you very much. Now we have another question. How has been the experience in arbitrating technologies disputes in ICANN, the Internet Corporation for Assigned Names and Numbers? Do you have any thoughts to share about that?
Yeah, unfortunately, I don't have a lot of experience with ICANN, so I'm not really qualified to comment, though I know there are people that engage in that practice pretty extensively. So I'm sorry, I don't have much to say on that one.
Okay. Well, it seems like so far is the thing that we have, so I'm going to take it to also present you another question. Now, the arbitration goes into technology disputes. But what is your experience or your thoughts about that technology itself is the way to solve the dispute?
Yeah, and we're seeing more and more technology sort of integrated into the dispute process. I think there were leaps and bounds in that development over the course of COVID, where, you know, arbitrators were early adopters of remote technology, and a lot of that work was done remotely even prior to the pandemic. And then, now we have full evidentiary hearings and things that are conducted entirely remotely. So we've seen vast improvements in those types of technology, which, the amount of the cost savings for clients is immeasurable if you can move those proceedings remotely. And there are a lot of other sort of efficiency advantages to that. I think, we saw a lot of sort of procedural innovation along those lines. So, some arbitrators now, instead of presenting your openings live, they do what's called a Cohen capture, where you pre-record in a single take your opening, and those are exchanged at an agreed upon time and given to the arbitrator, so that you aren't wasting time in you're not wasting that valuable hearing time where you have a lot of lawyers sitting around billing by the hour. So we've seen a lot of, and then there are other sort of attempts to have these sort of AI related dispute resolution processes that I think, many of them are being sort of tested out right now. It'll be interesting to see what we end up with, but I think there's a lot of potential there.
Okay. Miguel Ángel nos comparte Kleros. I think it should be maybe it's an algorithm or something related to dispute. Maybe Miguel, if you are there, I'm not sure if you want to share. What is this?
Yeah, I'm here. Thank
Okay.
you, Sarah, for your conference. It's quite interesting as always. And have you ever heard about Kleros? It's an Argentinian, platform. And they're handling arbitration. I don't know if you have heard something about that. Thank you.
Yeah, and I think, as long as you're careful about the AI involved and ensuring that there aren't biases built in, I think there is a lot of potential there. The other area where we see technological advances improving the efficiency of these disputes is in discovery. We're a long way away from exchanging, disclosing paper documents, and now, there's technology that can sort through massive amounts and quantities of material and identify relevant things really quickly without, a lot of human interface. So I think we're seeing, huge leaps forward there as well, and that's cutting down on attorney time and increasing efficiency, which is all to the good.
Okay. Well, I think it's been a really productive session. We're really glad and thankful for all that you share with us, and you let us clear all your experience, but also how these new trends are working, and you give us a lot of things to consider for our own practice. So thank you very much. And Karen, we go back to you.
Thank you very much, Agustin. Thank you, Sarah. Thank you again, Sarah, for talking about this important subject. Thank you for this important conference for us. And we hope to have you very soon here in Guadalajara with us. Thank you very much, Sarah. Thank you to all our participants, to all the persons here. Thank you, Miriam. Thank you, Pedro. And now, Pedro, we hear you. Thank you very much. Thank you, Sara.
Muchísimas gracias.
Gracias, Sara. Pedro, adelante.
Gracias. Pues muchísimas gracias. Thank you, Sarah, for your advices. Y muchísimas gracias, Karen, Miriam y Agustín, por tomarnos en cuenta al TEC de Monterrey como una plataforma para que nuestros alumnos puedan conocer estas ventajas del arbitraje y también de las nuevas tecnologías, ¿no? Para utilizar el arbitraje. Creo que fue muy provechoso para nuestros profesores y alumnos poder participar en esta sesión y a poder aprovechar todos los consejos y la experiencia de Sara en este tema, ¿no? Muchísimas gracias y esperemos podamos seguir colaborando con el colegio para realizar otras actividades que promuevan el arbitraje. Muchas gracias.
Gracias. Miriam, tenemos un reconocimiento, ¿verdad?, para Sara. ¿Quieres compartirnoslo? Listo. Sara, pues muchísimas gracias nuevamente de parte del Colegio de Corredores Públicos del Estado de Jalisco y del Tecnológico de Monterrey y la Escuela de Ciencias Sociales y Gobierno del Tecnológico de Monterrey. Te otorgamos un reconocimiento, Sara y Reynolds, por su destacada y valiosa participación como expositor en este curso. Muchísimas gracias. Thank you again, Sara.
Thank you so much. It's been such an honor and privilege to speak with all of you, and I wish you all well.
The honor is for us. Thank you. Gracias.
Buen día.
Gracias, buen día. Thank you, Sarah. Pedro.
Gracias, Pedro. Gracias,
buen día.
Miriam.
Miriam, gracias por todo.
Gracias.
Hasta luego.